Yes, may I please, Your Lordship? I beg to mention item 1112 on behalf of additional AG V. Shukre. This matter may kindly be listed after 2 weeks, Your Lordship.
Item number 12.
11 and 12. The analysis is from the hearing, please.
I have no objection.
Ms. Ina Holly, Learned Government Council, submitting on behalf of additional AG.
Yes, Your Lordship, V. Shukre.
Additional AG V. Sucre seeks, who seeks
3 weeks.
3 weeks time in this case. Ms. Lushino, Learned Counsel for the appellant, does not raise any objection, hence the prayer is allowed. Let this matter be listed after 3 weeks.
Your Lordship, I have a similar prayer for item 13 and 14 as well, Your Lordship. The set of parties are the same, so the prayer will also be the same.
Order will also be the same,
It's
same order.
fine. Much obliged, Your Lordship.
May please, Lordships. My Lord, I beg to mention item number 6. My Lord, here, one district petition is pending. The detaining authority has issued confirmation order. So I pray that we may be allowed 1 week time to file IA.
Heard Mr. A. Zo, Learned Counsel for the
B.
petition.
Soto, my Lord, B. Soto.
Sorry. Was heard Mr. B. Soto, Learned Counsel for the petitioner. Also heard Ms. Ina Holly, Learned Government Counsel. Learned Counsel for the petitioner seeks leave of the court for filing an interlocutory application
Yes.
in view of certain developments which has arisen in this case. The prayer is allowed. Let this matter be listed after
A week.
a week.
Much obliged.
For admission, item number 1.
Yeah, please, Your Lordship. Worship here, before the learned amicus query makes a submission, Your Worship, an affidavit has been filed by NHIDCL, respond number 6 and 7 on 15/7/2025. Though the copy has been furnished to the learned senior counsel amicus query, I have not been furnished copy of the affidavit, Your Lordship. So if NHIDCL may be directed to furnish a copy of
Okay.
the affidavit
Okay.
dated 15/7/2025.
And yes, Mr. Marshall.
Yes, the counsel for NHIDCL, I'm informed he is coming.
Lordship, my senior due to some personal difficulty, he couldn't be able to reach on time. He's on the way.
Okay.
Lordship, then let it be.
Let,
because-
let the affidavit be furnished.
Yes,
We'll take the matter later.
or maybe because he may like, who knows, he may require instruction because Lordship on 30th of May. Because of there was an accident where because of rock fall, driver was killed there. So that is the issue. And the affidavit has been filed by all the concerned authorities. But then it appears
Oh, okay, we are giving 1 week time.
let it be next witness day,
Okay.
so that
Okay.
that issue is taken up.
Third, Mr. Takamasha, Learned Senior Counsel. Who learned senior counsel and amicus curiae in this case. Also heard Mr. Imti Imsam, learned additional AG for respondent number 3 and 4. 3, 4, and 5. Who else is appearing?
I am for respond number 9.
Yes.
TB Japan.
Mr.
NHIDCL for respond number 6 and 7. More. More,
What is your name?
Indi Jang Lordship.
Mr. Imtijang, appearing on behalf of Mr. Muazzamir, learned counsel for respondent number 6 and 7. And Mr. N. Longkumar, appearing for respondent number 20.
Your Worship, authority engineer is here. Mr. George, your correspondent. 17. Respondent 17.
He's appearing in person.
Yes. Yes. Yes.
Respondent number 17 appears Mr. George.
Authority engineer.
Respondent number 17 is present in person before the court. So, learned Mr. T.B. Jamil, learned counsel for respondent number
D.
19 has submitted that the NHIDCL had filed an affidavit on 15/7/2025. However, he has not yet received a copy of the same. Stop. In view of the submissions made by learned counsel, the respondent number 6 and 7, learned counsel for respondent number 6 and 7 is directed to furnish copy of the affidavit filed by said respondent on 15/7/2025 to Mr. T.B. Zamir, learned counsel for respondent number 19 within a period of during the course of the day. Let this matter be listed again on,
Next Wednesday, Lordship.
yes, next Wednesday is
27.
27th of August.
No, August. For admission, item number 2.
Your file,
Wait, please, your lordships.
yes,
Lordships, the affidavit which has been filed by the respondents 2 and 8.
yes.
May I take your lordships to the contents of that affidavit?
It's not on record. Where is the copy? It is not on record. Is it on? Okay. It is not on record.
Oh, I see, your lordships.
What you want to submit?
Your lordship, so they have filed an affidavit. The respondents 2 and 8 have filed an affidavit, and they have enclosed an action plan. But unfortunately, it's not there before your lordships. Otherwise, the action plan is about temporary restoration. It's not about the actual proper representation of the highway. It is just about the temporary restoration. So a little shortcoming on the part of the NHIDCL. I'm sure, your lordship, that was not the intention. We wanted a permanent action plan for a permanent solution, not a temporary restoration.
Presently, the issue before the court was temporary restoration, though we asked for a
Yes, my lords. So the temporary restoration was already ongoing, my lord. Temporary restoration was already ongoing. But because of the collapse of this 100-meter stretch of road, the existing scope of work does not cover that. So therefore, they must come up with a proper action plan for a permanent solution.
Yes.
That is the point, your lordships.
The expert already dealt with the season 2. Well, they have submitted a report. The report is continuing according to the temporary restoration. And their recommendation is that the permanent solution can be taken up only as when the favorable weather condition leads.
No, but you can prepare an action plan. There was a query by this court regarding land acquisitions.
Yes.
Have you
So with
mentioned,
regard to that, your lordships,
have you
with
mentioned,
regard to that, yes, it is mentioned in the affidavit of the NHIDCL. So what the NHIDCL is saying is they're following the policy of the government. They're not following any law. I fail to understand how the NHIDCL can come up with such a stand, my lords. Policy cannot override statutory law.
Mr. Zimomi,
Yes, my lords.
let the affidavit be on record.
Very well, my lord. Then we can take it up next week then, your lordship?
Next
Or should we
week.
wait?
Yes, we'll fix this.
Very
matter.
well then, your lordship. Next week then, my lord.
Lordship, regarding I represent the state respondent regarding the acquisition. Now it is in the final stage, but because of the paucity of time, I could not file the affidavit. On the next step, we'll file the affidavit regarding the acquisition of that particular portion of land.
Okay. Third, Mr. A. Zimomi, learned amicus curiae appearing through video conferencing. Also heard Mr. Imti Insong, learned additional AG appearing for respondent number 3, 4, 5, 6, 7, 11, and 12. Also heard Mr. Yes,
Appearing for respondent number 10.
Mr. Senti Anger appearing for respondent number 10. Mr. Muzo is present. Who is appearing for 13 and 14? Okay. Also heard Mr. Moa Zamir appearing for Learned Council appearing for respondent number 1, 2, and 8. Mr. Zamir Mr. Moa Zamir Learned Council has submitted that in pursuant to the directions given by this court by its order dated 13/8/2025, the NHIDCL has filed an affidavit including the action plan for restoration of including the action plan as was asked by this court. Stop. However, it appears that said affidavit is still not on record. The registry is directed to place the said affidavit on record and let this matter be on record. Stop. Mr. Imti Imsong, learned additional AG, has also submitted that the affidavit which the state respondents intend to file is
Regarding the land acquisition.
regarding the land acquisition is almost ready and needs some time to file the same. The prayer is allowed. Let this matter be listed again on 27th of August.
Much obliged, Your Honors.
For admission, item number 3.
Yes, what is this? That order?
This is order dated 26, 20 May 2025. Let me come your lordship to para number 2. Lordship, in view of the above, it is requested to inform the Honorable Court that the stretch from Pimla to Mainamshi of National Highway 298 was included in the ID dated 28/11/2024 through corrigendum issued on 10/12/2024. Next page is the corrigendum.
Yes, Mr. Zimomi.
Yes, my lord. So both the letter as well as the order may be taken on record, your lordships, and then appropriate orders passed. Your lordships, in the PIL, the judgment and order dated 17/11/2021, a period of 3 years was given to the MORTH to construct the highway. So 3 years, we are well past 3 years now, your lordships. The judgment and order is dated 17/11/2021. So since the process has started, the PIL can be closed and the MOD can be given a timeline to build the National Highway 329 in terms of by taking this letter and order also on record, your lordship.
Who is appearing for?
Lordship, I'm appearing for respondent 28. I'm one of the interveners. 9MC village. I've been arraigned as a respondent 28 after the petition has been allowed by the government.
Who will be the executing authority? NHIDCL or?
Oh,
Your lordship, the MOD ministry will decide, my lord.
Now only tender
The
has.
DPR is being prepared now.
So you have to.
Mr. Lordship, my lord, I'm appearing on behalf of additional AG, Eldest Sultan. My lord, he is on leave, so let the matter come up next week, my lord.
No, you have to who is representing Ministry of Road, Mr. You have to give us a timeline because the judgment specified a time, 3 years, earlier judgment.
No.
So unless you give us a timeline, that tentative timeline, how this court will impose the time? Yes, Mr. Zimomi.
Your lordship, earlier in the disposal of the PIL, your lordship, considering the facts and circumstances of the case, 3 years was given. Now it's another matter that the MOT was sitting over the matter all these years. Also, since the DPR, the process has already been initiated by that NIT corrigendum dated issued in year 2024. Your lordship, if I may humbly submit, another period of 3 years would be very reasonable for the MORTH.
Why 3 years again?
Usually, your lordships, the contract of this nature, about 2 years is given from award of the NIT to actual conclusion of the contract.
Leave it to Lordship, I suggest 3 years then, Lordship. I suggest 3 years then, but I leave it to your Lordship.
No, you give us a plan that you give us an undertaking that yes,
In your tender,
yes, in the
Lordship,
tender which has been floated, time limit must have been given.
My lords, the completion of the work is another aspect, but as far as the requisition and acquisition of land is
Those
concerned,
process-
it has to immediately start, my lord. If another 3 years without ascertaining or specifying the nature on which the work is to start, then my lord, it may go for another 5 years.
Yes.
So I agree with the suggestion.
In that Lordship, give me some time, I will speak with the registry. Regarding that time.
And the government stand, who will be the acquiring authority? State government.
Yes, ma'am.
Yes.
So their stand is also required.
Is a
No,
lot.
your lordships, if I may, your lordships, in terms of the National Highways Act, the central government designates a competent authority for land acquisition. And if your lordships will recall, on the last occasion, my learned friend Mr. Moore was saying all the deputy commissioners have been designated as a committee, the competent authority on land acquisition. So there is no reference to the government here, your lordships. Straight away, an acquisition case must be registered by the competent authority. That's how it should begin in terms of the National Highways Act 1956.
Petition of the application DTH from the issue in the acquisition.
No, I didn't.
What steps in the time of this acquisition and then link to
Yes,
yes.
Mr. Zimomi,
Yes, my lords.
since the process involves different phase, like
Yes, my lord.
acquiring of the land, only
Yes, my
then
lords.
the construction work may start.
Yes, my lords.
Can you assist this court to give a timeline that this much time would be required for
Yes.
in the process, so that so that this court may fix a time instead of on just speculative time of 3 years or 2 years. We don't want to give that.
Yes, my lords. My lords, in terms of the Acquisition Act, from the inception to conclusion of the acquisition proceedings, there's a time limit of about 1 year, and that is it can be finished any time before that period also, Your Lordship. And usually for construction projects of this nature, about 2 years is given from award of the contract till conclusion of the contract. So that is the time frame that we are looking at, Your Lordship.
For work is awarded to acquisition and acquisitions.
If vendor has to be flooded, then well, that has to be acquired. So at least minimum 3 years, I pray that treatment is be given to them. Because it will take time to acquire the land only, so it will take time. Some of the landowners, they may not be able to give them, so they might be willing to participate, willing to give their land also. There are situations like that.
Your Lordship, as far as this case is concerned, my learned senior, Mr. H. Mumi is representing the landowners. I'm also representing the Mainamsi village. As far as land is concerned, nobody is saying that we will not give our land. So
But
there is no issue with that. The requisition and acquisition process has to immediately start, my lord, so that the
In
project.
any case, for construction of national highways,
Yes,
you
Lord.
cannot have an objection, you will not listen to objections
Yes,
from
Lord.
landowners.
Yes, Your Lordships. It's compulsory, Your Lordships.
What I want to say is that the road from Kohima to Timor, there was some objections, and some part of the land would not be constructed because the land already had.
That is precisely the problem, Your Lordships. Your Lordships will recall in the earlier cases I was mentioning this. The NHIDCI and the state government, I do not know why they are not following statutory law in relation to acquisition of land. The so-called policies, that is what is impeding the entire developable projects in the state, Your Lordships. They must follow the law. They're not following the law.
The Lordship, I noticed that some portion of the land has not been dug into because of the interference by some landowners. That is the problem, Lordship.
That's a different road, my lord. As far as this road is concerned.
I hope that in this stretch of land, they will not issue, that will not be issued, but issue crop up, Lordship. That is why.
But as my lord has observed, once acquisition proceedings are initiated, no one can object. Acquisition in public interest is compulsory, my lords. It's because that they're following this policy that all these pleas are coming in and these objections and obstructions are coming in.
Okay. No, let the state government also put forward their submission who is appearing additional,
Additional AG LT Sangdam.
let him also appear, and young Mr.
Yes, he's on leave, so let the matter will come up next week.
Okay, heard Mr. A. Zimumi, learned counsel for the petitioner. Also heard Mr. Yangarwati, learned Central Government Council, appearing for respondent number 1. Mr. Joshua Sheki, learned counsel for respondent number 8. Mr. Muaz Zamir, learned counsel for respondent number 6 and 7. And Mr. L.T. Santam, Mr. T.E. Tibafom, appearing on behalf of Mr. L.T. Santam, learned additional AG, appearing for state respondent number 2, 3, 4, and 5. Mr. Yangarwati, learned Central Government Council, has placed a corrigendum dated 10th December 2024, issued by the Ministry of Road Transport and Highways, which indicates that the stretch of road from Pimla to Mainamsi of National Highway number 329A has been included in the NIT dated 8/1/2024. Stop. Let the letter produced by the learned Central Government Council be part of this, be placed in this record as a part of it. Stop. Mr. A. Zimomi, learned counsel for the petitioner, has submitted that in which was the earlier case number?
Your Lordship,
PL number 3 of 2021. PIL number 3 of 2021.
As the time limit which was prescribed for completion of the construction of National Highway number
P29A.
P29A which was given by this court, that is 3 years, has already been lapsed. Considering the nature of the work, another 3 years time may be granted for completion of the construction of the said National Highway. However, Mr. E. Tibafom, appearing for the state respondent number 2, 3, 4, and 5, has submitted that as Mr. L.T. Sanktam, learned additional AG, is on leave, so this matter may be listed next week. Stop. He prays for listing this matter next week. Stop. This court requests Mr. Yangarwati, learned Central Government Council, as well as the Council for the State Respondent number 2, 3, 4, and 5, to indicate to this court on the next week as to how much approximate time would be required for completion of the acquisition proceeding for construction of the said National Highway, so that a timeline may be given by this court for completion of the construction of the National Highway number
329A.
329A. Next week you propose us.
Hey, please, your lordship. Lordship, may the letter dated 20th May also be kept on record.
Yes, it's.
Yes.
Along with the corrigendum.
The letter dated 28th May 2025. Produced by learned Central Government Council before the court today may also be kept in record as part of it. List accordingly on,
Should I be given a copy of the order?
yes,
27.
list accordingly on 27. Let a copy of this order be furnished to Mr. Yangarwati, Learned Central Government Council, as well as Mr. E. Tiba from Learned Council appearing on behalf of Mr. L.T. Sant, E. Tiba from stock. List accordingly.
For admission, item number 4.
This one is Lordship, aggrieved by the decision passed in with petition civil 305 2021, which was dismissed by impugned judgment and order CAV dated 27th of June 2023. The instant writ appeal has been filed. Lordship, the facts in a nutshell is that the petitioner, who is the appellant here, was appointed as work charge Kalasi on fixed pay under the PHED department. Public health.
Both
Department.
parties are ready for final disposal.
Yes, please.
Okay. Yes,
The appointment was dated 23rd of May 1984.
where is the impugned judgment?
The impugned judgment, my lord, will find it annexure. Lordship.
70.
69 annexure 5. Lordship.
Okay. Yes. Yes.
The observations of the judge starts from paragraph 12. However, before coming to that, Lordship, after having appointed on 23rd of May 1984, the petitioner served for 35 long years, Lordship. And he was discharged by order dated 24/5/2019, my lord, after having served for 35 years. Now, 35 years is the longest time that a government employee can serve under the government service rules under government of Nagaland.
What was his age then?
My lords,
At the time of his discharge, what was his age?
my lord,
What is his age now?
I'll have to check. Lordship. At the time of filing the appeal, he was 57 years.
57 in 25. 6 years ago, 51 years.
As per the affidavit, my lord.
Yes, yes. Yes, please continue.
Yes.
The writ petition, yes, Lordship, in the writ petition, at the time of filing the writ petition, he was 55 years. So, on length of service, my lord, he was retired.
I'll just interrupt you once more.
My
He
lord.
was appointed in 1984.
Yes, my lord.
What was his age then? If he was
Yes, my
54,
lord. Yes.
in two thousand
I
twenty-five.
believe around 18 years, I think.
Cannot be.
Because,
57 is in 25.
yes, my lord.
So 47 is in
Yes.
2015.
18, lordship, around that, I think.
2015 is 47.
Yes, lordship.
Then 37 is 2005.
Yes, my lord. If 55, 35 is
27
removed from
is
55 and 20 remains, my lord.
25.
And he was retired in, this petition was filed in 2021 and he retired in 2019.
In
So if-
1985, he is 17 years, if my calculation is correct.
My
So
lord.
84, he'll be 16 years. Could he have been appointed?
Rightly or wrongly, my lord, he was
Rightly.
appointed. lordship.
Okay.
The fact remains that he was appointed,
Okay.
my lord, and he was allowed to continue without any interruption in his service for 35 long years. And in 2019, he was released from service after having served the department for 35 long years. Now, lordship, he
Yes.
is somebody who is employed in manual works, my lord. These are for credits. So he had little education, someone who can hardly write his name. Therefore, requires for regularizing his service and for awarding pay scale to him, they have met during their service tenure to their higher ups, my lord, verbally, on many occasions, my lords. However, because they are not directly serving under the chief engineer, they are only serving under the executive engineer or the STO civils in the district level. So at the district level or within their office, those are the top posts. So again and again, the request was made. And despite verbal assurances being given that they are also exposing their cause before the higher ups at the directorate level and the top at the government level, nothing positive materialized. And he was made to leave empty-handed. Now, my lord, a representation was made to the state respondents, particularly the chief engineer, who is the head of department of the PHCD department, on 28th July 2021. However, when this representation was not considered, my lord, it was not considered neither negatively nor positively, my lord. Therefore, the petitioner, having no other alternative efficacious remedy, have approached this honorable court under Article 226 of the Constitution. Thereafter, my lord, the contentions in the writ petition was that, my lord, there were so many other similarly situated employees, work charge employees, my lords, for-credit employees, who were awarded scale of pay. The RTI information that was received from the department was also an executive petition. 380 were awarded scale of pay, my lords, because awarding scale of pay is important here, lordship, as per the work charge regularization scheme adopted by the government of Nagaland. There it is specifically provided that somebody who is a work charge and is receiving scale of pay, my lord, and has served the department for 30 years, then he'll be regularized. That is automatic right. However, how a work charge employee is to be awarded scale of pay, there is no scheme. There is nothing regulating the award of scale of pay to the work charge employees, which is why it is being given to the work charge employees in a pick and choose manner. So 380, my lord, and many of them are junior to the present petitioner. And my lord, the regularization is by converting to the post they are holding into regular ones personal to them. It is clearly mentioned in the office memorandum 2015. It is not that they are being regularized against a sanctioned post. The post is converted into a regular one personal to them, my lord. That is the exact words used in the office memorandum. So, Lordship, in all those years, he was not awarded scale of pay. Now again, my lord, 195, many of whom are also junior to the present petitioner, the present appellant. They were regularized work charge employees. But the petitioner's case was not considered, my lord. So, on the violation of Article 14, my lord, and
On what grounds the writ petition were
my lord,
dismissed?
it starts from paragraph 12. If I may take my lords to Annex 5, page 69 of my writ petition.
What is your contention? Where the single judge heard?
Yes, my lord. The observations of the learned single judge starts from paragraph 12.
Yes.
In fact, my lord, this is off the record, but this was delivered by my lord Justice Kohima. So he is a compassionate, kind judge, and he was very much when the petition was initially moved, very much in favor of granting the allowing the writ petition. However, during the pendency of the writ petition, a division bench decision was passed, my lord. And basing on and since the single bench has to follow the decision passed by the division bench, he had to later on, my lord, this decision was passed. So, my lord, from paragraph 14, if I may be allowed to read.
Yes.
That the government of Nagaland, on due consideration of the, my lord, if I may be allowed to start from paragraph 13, this is important. Do regulate appointment and conditions of service of persons appointed as work charge and casual employees in state of Nagaland. The Nagaland Work Charge and Casual Employees Act 2001 has been enacted. Section 2D of the Act defines work charge employee to mean an employee engaged without sanctioned post under work charge establishment. Section 12 of the Act 2001 then provides for the scheme for absorption of service and stipulates that the state government may draw up a scheme for absorption of service of work charge employees into regular government service. So, my lord, the intention, my lord, there is an express intention of the legislature to regularize work charge employees, my lord. And with that intention, my lord, the 2001 scheme office memorandum was brought out, 2004 office memorandum was brought out, 2015 office memorandums were brought out during the service tenure of the present petitioner, my lord. Now, my lord, in paragraph 14, it speaks about the 2015 scheme, my lord, that which was holding the field when the present petitioner retired. That the government of Nagaland, on due consideration of the report of Work Charge and Casual Employees Commission and in compliance with the judgment and order of the Honorable High Court, has framed the scheme for regularization and absorption of work charge and casual employees and the revision of their pay and wages by issuing OM so and so dated 17/3/2015. The relevant criteria for regularization as stipulated in OM dated 17/3/2015 is reproduced below. This is important, Lordship. 1.1. Regularization in service. Roman 1. All existing work charge and casual employees of various departments who are enjoying scale pay and who have completed 30 years or more continuous service as on 1/1/2015 will be regularized by conversion of their post into regular ones personnel to them and subject to fulfillment of conditions as indicated below, my lord. So, Lordship,
Yes.
The main qualification required under the scheme was that
Scheme provides that under working that most which was only. Yeah, key is a post factor regularization is
We can we can consider also.
para 15 now.
So
Yeah, there is and
para 15 is full representation like the latest relation. Should we consider?
yeah, post factor regularization. They have a equal. I assume.
Most factor relation. Itu office member basically he scale of it. Kita scale of it masili. He separated it on Kuzili. The nuclear score most of it again. You are all on PhD. Relating the day. Itu saja. Jadi kini possibly perceive. Kini dulu kita sahabat modal ini pasal modal যেহেতু আমি তাই কথা বলবো তাহাঁতৰ শুদ্ধ আছিল নে ভুল আছিল আমি চাব নোৱাৰো যদি ভুল আছিল আমি নিগেটিভ ইকুৱেলিটি দিব নোৱাৰো so believe to meet in particulars for us to decide
Otherwise, so could be only to this in the case where assuming a scale of place where insert for 35 years, then you need time without regularization. In those cases, regularization, what is to be done? Vacant post on the vacant post on the post token,
personal equity.
But supernumerary post, what is the concept?
Supernumerary post it was created for a particular purpose and it dies the data purpose with the person who built that post. তাহলে বেলে কোনো হেল্প মানে এই পোস্ট হলে কোনো ভাবে প্রমোট হবে না that post dies the moment the moment in service মানে যদি কেউ রিটায়ার হয় এটা পোস্ট না ইমিডিয়েট হয়ে গেল সো তার এখানে স্পেশাল বাজেট প্রয়োজন হয়ে গেল so it will retire
You will get pension.
he will get pension if he was also supernumerary post it would difficulty নেই কিন্তু এটা ক্রিয়েট করবো বলে it's a long term thoughtful process of government and the one will better post to it's like a post creation
My special purpose.
Kill
This one judgment of both also merits.
supernumerary will be treated as a court of judgment to reason to replace supernumerary to treat going the financial objection to even by and going to
So many appropriate cases. Most is not happening. But otherwise, good things that
Nihal Singh is somewhere and Nihal Singh will say that was the signature person to be able to the post will not fall from heaven. Government has to create the post. One of point is also come by said that if the only reason is that there is no such something usually go for post to point is also to media to media so now create
and seems otherwise found in this case may be different.
this is because of the appropriate use of developers in Nihal Singh to terminate supernumerary perspective. Don't have to be person. You will surrender to a system to be played then put away. Don't have one in the deal. So, it would duty to the bank of money. That is pretty then what want to money one bank on the river. So, how can you do as a regulation? It's supposed to be from heavy. Since some post B and we will score.
Yes, that was it.
My lord, in fact, my lord, this is already a covered case. It's a decision passed by the division bench of this honorable court on the same question of law, same department, and same length of service, my lord, 35 years. And dissatisfied with the division bench decision passed by this honorable court. The state went for appeal before the honorable Supreme Court. The Supreme Court has dismissed the state's appeal, my lord. And the division bench decision, which was existing at the time when the single bench decision was passed, my lord, in the Indian decision here. That has been declared per incuria, my lord, by the division bench decision reported in.
No, we are not getting it. This case was covered by a division bench judgment which went up to the Supreme Court, and Supreme Court dismissed the appeal filed by SLP filed by the state.
Yes, my lord.
So,
My lord, at that point of time, there was another division bench decision
okay,
which
went against you.
yes, which went against me. So based on that, this present decision was passed, my lord.
Yes.
Now, after that, my lord, in another case, my lord, the division bench decision which was holding
Against
against me, it was declared per incuria
by the
by a division bench of this honorable court, my lord, because there are other division bench decisions which was passed prior to the division bench decision, which
is the decision which supports your case? The first division bench decision you are talking about?
Ramaswamy, my lord.
No. Division bench judgment.
Yes, my lord.
What is that?
Now that all those decisions are, my lord, referred in this 2024-1 NLJ 384, my lord.
The facts are the same.
Yes, my lord.
What
Facts
is-
are,
Those persons also did not draw a scale of pay.
no, my lord.
They did not draw
No,
scale
no,
of pay.
What is the citation?
2024-1 NLJ 384, my lord. The division bench decision passed by my lord Justice Robin Fukan and my lord Justice Puti Habong.
1 NLJ page
384, 384.
84.
What it says?
It says that, my lord, I am entitled to be paid pensioner benefits, my lord. Because, my lord, firstly, there's a welfare act, a beneficial legislation, my lord, and there's a welfare scheme, my lord. And when two interpretations are possible, the one which benefits the employee must be adopted. Firstly. Secondly, my lord, similarly situated employees have been awarded both scale of pay as well as pensioner benefits. They were recognized, my lord. But the petitioner therein, my lord, was left out. So on that ground also, my lord, and then when there are two conflicting division bench decisions, the division bench decision which was passed first, my lord, it must be relied upon as per the decision passed by the Honorable Supreme Court in 2017 16 SCC 680 I think. The 5 judges bench decision, lordship. Pranay Sethi, my lord. So, at the cost of repetition, dissatisfied with this decision, my lord, the state preferred an appeal before the Honorable Supreme Court. Supreme Court have dismissed the appeal.
This cognac.
Yes, my lord, my lord.
Okay. Yes, state, what do you say about this?
My lord, regarding the pending SLB, which was
It's no longer pending.
dismissal, it was withdrawn. It was not dismissed, but it was withdrawn.
No, my lord.
Dismissed as withdrawn.
Yes, my lord,
Without
on the
liberty.
ground,
I've sent my juniors to bring.
my lord, on the ground that state is framing a policy to grant scale of pay to the fixed pay. Those are enjoying fixed pay.
No,
So
that's
on
a
that-
different case, Lordship.
Yes,
He did
so
not.
we are relying on that judgment, my lord. So my lord, this case is covered by two judgment. It is already reflected in the single the judgment passed by the single benchmark. I'm relying on that two judgment. It is already.
When you withdraw the SLP before the Supreme Court
Yeah.
without any liberty or anything, I presume there was no liberty. But if there is no liberty, then that SLP part is gone. So 2024 judgment in Konyakwil, State of Nagaland versus Konyak will prevail, which says that the judgments which you are relying upon or the learned single judge relied upon are per incurium. We have not gone through it. That is what I understood from his submission. So if you are relying upon per incurium judgments and the learned single judge relied upon per incurium judgments,
My lord, here that state is preferred a bill.
Where is that specific paragraph where?
that per incurium part where you,
My lord.
Article 57, Article 57. Yamaswamy, Bhagavan Singh. This writ appeal 27 of 2022 is this Nishievi Achumi, same case.
No, my lord.
Which one is it?
Alamba. It is Alamba. State of Nagaland versus Alamba.
Nishibi is markedly different from my case. my
Alemba,
lord.
prayer 17.
27 of 2022.
Mhm.
Nishibi has also been discussed in this division bench decision, my lord, and the division bench decision held that, my lord, the two cases are not similar. In Nishibi, the government employee died, and the wife approached the court after a delay of more than 10 years, my lord. And the court has also observed that at the time of the death of the government employee, he was not entitled to be regularized.
And where do we find that this person was also on a fixed pay?
My lord, in paragraph 4,
Hmm. He filed an application for upgradation of his salary from fixed pay to scale pay. What was the prayer there? But there he had approached the court when he was already in service.
no, my lord.
Yes. Let us read para 4 again, 386. Thereafter, by order dated, so please read the paragraph at page 386. Government of Nagaland starts, no? The page starts at Government of Nagaland.
This therefore by order,
Hmm.
dated 3/9/2000, the petitioner was released from service with effect on 3/9/2019 after completion of 20 years.
Hmm.
While he was in service,
Ah.
he had filed one representation.
On 7/9/15 for
Yes,
upgradation.
my lord.
Then, but the same was not considered.
Yes, my lord.
Thereafter, on 8/8/19, he
Yes.
filed another representation.
Yes, my lord.
He was released on 3/9/19. But in your case, the letter single judge had also observed that you did nothing when you were in the service period.
Yes, my lord.
Yes, my lord.
Now, in paragraph 18, my lord, of the same decision, my lord.
Hmm.
the learned division, the division bench have quoted with approval the decision passed by the learned single bench, my lord. In paragraph 6, it has been observed, my lord, if I may be allowed to read.
Which para? 18?
18. In 18, the learned single bench decision has been quoted, paragraph 6,
Yes.
if I may be allowed to read. I have considered the submission of both the learned councils, keeping in view the facts and circumstances which have not been disputed. The pay of 380 work charge employees, majority of whom were junior to the petitioner, were upgraded to scale of pay by the department. Leaving aside his case, in spite of the application submitted to the respondent number 3, the service of 195 persons who were all junior to the petitioner were regularized, and that too without meeting the requirements of the provisions of the office memorandum referred to by the learned government advocate. Here also, Lordship, all the 195 are junior. I am of the view that the petitioner has been discriminated. Since the petitioner had served the department without any break for so many years, he should have been given the same benefit when he had asked for it. Even without asking, Lordship, this is important. The state as a model employer and under a democratic form of government and being a welfare state should have done it. Having not done so amounts to exploiting its own citizens for 35 years and releasing him empty-handed. My lord, the order dated
Just a minute. Yes.
So, my lord, the learned division bench, honorable division bench of this honorable court, lordship, has concurred with the decision passed by the learned single bench, lordship, that even without asking, even without representation, the government employee should have been regularized by the government, being a model employer, state being a model employer, lordship. Now, lordship, the Supreme Court decision, which was passed on 15th of January this year, which was not withdrawn, my lord. The withdrawal case is a different case.
Hmm? Hmm. This is not withdrawal, like you
Yes,
said.
lordship.
While we are not inclined to interfere with the impugned judgment and order passed by the High Court, the Supreme Court was not inclined to entertain your questions. The question of law raised by so-and-so is kept open for being considered in an appropriate case. But otherwise, your SLP has been dismissed.
Yes, my lord, after this order, state government has notified one office memorandum. That is, it was issued on 5th March 2025. And in that it says that their state government has issued that scale of pay will be granted to the fixed pay employees with effect from 1st April 2025. So even the petitioner is not covered by this OM also, my lord.
No, this OM came after disposal of these cases.
If he's not protected by your OMs, the court may come to his protection. Unless you show us this is different. Show us how it is different. Why we should not follow State of Nagaland versus Angfei Konyak.
Yes, my lord, that Angfei Konyak case, I'm not aware the facts.
Huh?
The facts I'm not aware regarding that Angfei Konyak case.
You have made a statement before this court that this matter was taken up in SLP. You are saying you are not aware of
No, I'm relying on the other case. That is Alamba case. That is. Ambai
Yes.
Punyak is different and the Alamba is different.
Yes. So
And-
show us how this, his case is similar to Alamba. Show us that. What is the Alamba case?
Alamba case in here also the petitioner.
Hmm.
Petitioner has completed 35 years
Yes.
and he was enjoying scale. No, he was enjoying only fixed pay.
Yes.
That is why he approached the court
Hmm.
to grant scale of pay for pensioner benefit.
Hmm.
However, by single bench, by single bench has allowed the petition. That is why state government preferred an appeal. And it was also dismissed by the division bench.
Yes.
Thereafter, the state approached the apex court
Hmm.
and filed SLB.
Hmm.
And in that case, state government has withdrawn the case from.
So even the Alamba case is not coming to your rescue. The single judge allowed it.
Yes.
The division bench dismissed your appeal.
Yes.
SLP gone. Alamba is not coming to your rescue. Show us something which is coming to your, which supports the case of the state. We are taking his word for it that this case covers his facts also.
Sorry, my lord. In that Alamba case, state has preferred appeal, and that appeal was allowed. It was allowed.
Where do you find it?
Your lordship, may kindly see this page number 78.
Yes.
The appeal memo, page number 78. Para 17. Para 17. Page number 78. Para 17. Appeal number 227 of 2022. State of Nagaland versus Sri Alamba.
Lordship, this has been declared peremptory.
Where?
This 17th decision. This is the judgment I was.
Yes, 27 of 2022. Yes. Have you given a copy of the judgment, this judgment to him?
It's a reported decision.
2024 1 LNJ 384. Have you gone through it, sir?
No.
No,
That is the difficulty. See, we have division bench for this for today. We are trying to take up the hearing. Okay, then you come to page. Let us help you then. 396 para 21.
And if I may, my lord.
Just a minute. Let us go one by one. We'll finish it up quicker. 396 you have?
Yes, sir.
Para 21 you have?
Yes.
Come to the last line directly. We'll read the rest of it later on. The last line, last two lines. Can you read from decision, the second last line? Page 396. The second last line from the bottom.
Though the decision in that one.
Huh? Decision, yes.
the decision is rate of.
Though the decision, yes, you read from the
Was discussed and distinguished and also that the decision bill numbers also not been taken into account in the decision with having when later in point of time the decision rate numbers also appear to be in
per incurium. So 27 of 2022 is per incurium.
Yes, my lord.
Learned single judge has depended on that.
Yes.
Has relied upon on that.
Yes.
The per incurium judgment.
Yes.
So your debt ground goes.
Yes. In this judgment, I have nothing to say, my lord. It is covered case, my lord.
Then it becomes covered.
Yes.
Save and accept the fact that these people had preferred representations when they were in service.
Yes.
And your petitioner did not prefer any representation when he was
In service.
in service.
Only after the retirement.
But again,
Yes.
this court has held, the learned single judge in his order held that you are the role model employer. Why should you wait for someone to come and beg before you?
Only after the retirement. from service.
But you should
Yes,
have done
after
it.
the-
You should have done it when he was in service. It was your duty to do it. You did not do it. So because he did not apply for it at that point of time, you may say that he will not be entitled to the actual monetary benefit. But he'll be entitled to his scale.
Yes.
He'll be entitled to regularization. He'll be entitled to his pension.
apart from this Alambas case,
my lord.
whether any other reasoning was given by the single bench? Well,
Lordship, Uma Devi, Lordship. And Nishibi's case, Lordship, which has been discussed by the division bench of this honorable court. Saying that Nishibi's case does not cover my case, because in Nishibi, my lord, the petitioner's husband expired while he was in service. And the wife approached the High Court after a decade, after about 12 or 17 years, my lords.
13 years.
13.
And what do you say about this?
And the court held that, my lord, in Nishibi, held that the Supreme Court held that at the time of the death of the government employee, he was not entitled to be regularized.
No, even in service matters, the family coming up asking for regularization.
Yes, my lord.
When the person himself did not pray for the same.
My lord.
The service matters are personal to that extent.
My lord.
If he was regularized, she came asking for family pension, it's another thing.
Yes, my lord.
But
My
what
lord,
he was entitled to cannot be asked by his family.
lord.
What do you say about this? At page 81 of your petition, come to page 80, para 19.
My lord.
How do you overcome that? Page 80, para 19.
My lord.
State of
My lord,
Manipur.
yes, Uma Devi. My lord.
Yes, there will be no direction for regularization.
My lord.
So,
My lord, I believe I will be better answered by 2019 10 SC 516, my lord. Prem Singh versus State of UP. I may be allowed to rely on paragraphs 31 and 36.
Prem Singh,
Yes, my lord. Each participant's decision of the Honorable Supreme Court.
para 31 and
36, my lord.
6.
If I may be allowed to read.
Yes.
In the aforesaid facts and circumstances, it was unfair on the part of the state government and its officials to take work from the employees on the work charge basis. They ought to have resorted to an appointment on regular basis. The taking of work on work charge basis for long amounts to adopting the exploitative device. Later on, though their services have been regularized, however, the period spent by them in the work charge establishment has not been counted towards the qualifying service. Thus, they have not only been deprived of their due emoluments during the period they serve on less salary in work charge establishment, but have also been deprived of counting of the period for pensionary benefits as if no service has been rendered by them. The state has been benefited by the services rendered by them in the heydays of their life on less salary in work charge establishment. Para 36, my lord. Here, Uma Devi has been
Also discussed.
yes, my lord. 36. There are some of the employees who have not been regularized in spite of having rendered services for 30 to 40 years or more years, whereas they have been superannuated. As they have worked in the work charge establishment, not against any particular project, their services ought to have been regularized under the government instructions. And even as per the decision of this court, instead of Karnataka versus Uma Devi, this court in the said decision has laid down that in case services have been rendered for more than 10 years without the cover of court's order, as a one-time measure, the services to be regularized of such employees.
You given any list of dates with your appeal or the petition? Is there a list of dates?
Yes, my lord. Whether the list of dates will satisfy my lord.
I will see.
Yes, my lord.
My lord,
Yes.
if my learner friend has completed his submission,
I'm making him complete. Yes. We'll try to make him complete it today as fast as possible.
My lord, on my daily lordship, again, recently another decision has been passed, which is reported in 2024 SCC online 3826. The decision was passed on 20th December 2024. Jagu versus Union of India.
SCC online?
2024 SCC online
Mhm.
3826.
Name?
Order dated is December 2020.
Party's name.
Party? The parties?
Chaku versus Union of India. JAGGO
Okay.
versus the Union of India.
GAGGO,
It's a
Jaggu.
very catchy name.
Ah.
Here they have discussed
Because based in Spanish, there is one Korean seeking the way to only use which is to get compassion. Accountable. When you come to inclusion. Kiki was in UC. With the name that is New Zealand. If you covers everything, then by beginning the understanding chance, 18 years, this project chamber of pleasure.
Yes, you are referring to?
Lordship, here in para 26, the relevant paras are 22, 25, 26, and 27. But in para 26, it speaks about Uma Devi should not be misused, my lord.
By the government.
Yes, my lord.
Give us a list of your books, a list of books to us.
My lord.
The judgments that we are relying upon in the para numbers, write it down in a list.
My lord, I'll do that.
And that list of dates I was saying, do you have it?
No, my lord, I'll prepare it and then I'll, if I may be allowed to submit by 2. I have annexed in the writ petition, but not
Yes,
in
that is what I'm
in
saying.
the writ appeal, my lord. So I'll
Where
prepare it
is
and-
there in the writ petition? Is
The
there?
writ appeal is missing, my lord, list of dates.
No, it is there, page 114.
Yes, my lord, this is the writ petition.
Yes. Yes, sir.
Yeah, my please lordship. If my
You're done?
friend is over the
My-
my lord, I won't take much time. I'll rely on the affidavit in the opposition file by the state respondent, my lord. Page number 169. 169 in the well memo, my lord. I'll be relying on para 4, 5 of my affidavit in opposition, my lord. Para 4, 5. 6, 7, 8, and 9. So in order to save time, I'm not reading this paragraph, but I'll be relying on those paragraphs, my lord. So my lord, my lord. Here, my lord, though the honorable court has given direction to consider the case of the petitioner to regularize the service. One question is, if there is no scheme, then how the state government consider their case?
Then you are in contempt of Uma Devi.
So no, my lord, my submission, my lord. So there is no scheme, my lord. Firstly, there is no scheme for granting of scale of pay. So in absence of source of law, the state cannot consider the case of the petitioner. That is my first submission, my lord. In absence of scheme or law. And the second submission, my lord, the petitioner is claiming is praying that under OM dated 17/3/2025. That is the only, my lord, in this scheme, 17/3/2025. That is not applicable in his case, my lord. Your lordship, that scheme, page number 1110, 110. Annexure 8.
One, one.
1110.
Yes.
Scheme for regularization and observation of work charge and casual employees and revision of pay or wages. Para 1 plus 1, my lord. Here it says that all existing work charge and casual employees of various departments who are enjoying scale of pay and who have completed 30 years or more continuous service as on 01/01/2015 will be regularized by conversion of their post into regular ones personnel to them and subject to fulfillment of conditions as indicated below. Here, the petitioner has completed 35 years length of service, but he is not enjoying scale of pay. That is why, violating this standing office memorandum, the state could not consider his case because he is not enjoying scale of pay. So, under this OM, the petitioner is not eligible, my lord. And the secondly, my lord, petitioner was released on 24/05/2019. Petitioner was released from service on 24/5/2019. And the petitioner submitted his representation on 28/7/2001. So the petitioner, he has never approached the authority while he was in service. So only after the service, after he was released from the service, the petitioner has approached the authority. Here, the petitioner is alleging that similar situated employees and his juniors were given the benefits, and subsequently their service has been regularized. So during in service, he has never approached the authority on the ground that his juniors have been considered. So, my lord, in that is why the learned single judge has relied on the Nisifi case. In the Nisifi case also, petitioner husband, he never approached the authority while he was in service. So only after the death of her husband, she approached the authority. That is why that case was not considered. So similarly, the single bench has relied on this judgment. And in the Alamba, para page number 78 in the judgment. Page number 78, para 17. Page numbers, and here also the single bench has relied on the Alamba case. That is read April number 27 in 2022.
But Alamba is.
Yes, my lord. So my submission is there is no infirmity in the judgment given by the single bench. So basing on this single bench order, this instant petition is liable to be dismissed. That is my submission, my lord.
Yes, Mr. Shekti.
Well, as far as the respondent number 5, the office of the principal accountant general is concerned, the file process has not been initiated. In fact, we should not have been made a party in the first place. And we have placed the same argument before a coordinate, not the division bench, but the single bench of this whole court, but it's yet to be considered. If not, we're not a necessary party. No process has been initiated,
Thing is, if there is an order in his favor
my lord.
and they do their part in compliance, then they will say that the respondent number by this accountant general is not taking steps. It will be difficult for
Yes,
them
my
to
lord.
come up in a contempt against you. So
Lord.
they have made you a
My
party.
lord,
We have
the same view has been expressed,
Yes, in
by,
matters.
the same
Because-
view has been expressed by lordships of this whole court as well.
This delay, what do you explain it? You did not do anything when you were in service.
Yes, my lord.
So why should the delay not be held against you? Just that much.
My lord, here, firstly, it's a question of infringement of fundamental rights, my right to life. And
Yes, but you
my
must
lord,
fight for it in time.
Yes, in Article 14 lordship.
Hmm.
And as I have been stating that firstly, lordship, there is no delay when the issue relates to fundamental rights. Lordship. Secondly, lordship, it is not that I did not make representations. I made verbal submissions, verbal requests, lordship. And lordship, me being an illiterate person, lordship, who knows hardly how to write my name, my lord. And lordship, my only scope, lordship, was to make requests to the higher ups at the district level, lordship. So at my office, I have made frequent requests on many occasions, my lord. And
Give us some law, either if you to show that delay will be fatal here or delay will not be fatal here.
my lord, in Lakeshwar TAS, I believe,
Hmm.
the decision
Yes,
passed by
what was the
Supreme Court,
decision?
that when the issue relates to pension, my lord, there is no delay. And the pensionary benefits, my lord, if it is more than 3 years, then
Curtail,
the time,
curtail,
yes,
curtail for a period of 3 years. That is what.
yes, my lord, my lord, my lord, my lord. Relying on the judgment passed in 2018, Tarsip Singh versus Union of India.
How does this delay affect the government?
My lord, here the case is in regard to granting of scale of pay.
No,
Only after granting of scale pay that
when it is
This is-
notional, if you go by the case that
it is not the
Supreme
pension
Court
case.
Supreme Court case, I forget. Anyway, the Supreme Court has held that when you are asking for pay, scale of pay, pension and others, there is no limitation 7 except to get the actual benefits. 3 years is
Right.
correct on that. What I am trying to ask you is how is the state prejudiced by his delay? Delay in lectures will be fatal to a repetition only if third-party rights have been created in the meantime, maybe. Maybe the situation of impossibility has come in. Then we go by delay in lectures that, okay, you are too delayed to now approach the court. Much water has flown under the bridge, now you go home. But how does this delay affect you?
My lord,
Because
here,
whatever he'll get notional.
yes, my lord.
He'll get something, a future benefit. So how can you say the delay is fatal to the case? Is the delay fatal to the case?
My lord, here the present case is the petitioner should first get the scale of pay.
Yes.
And the scale of pay is granted to the employees who are in the service.
Who were also, his juniors were granted.
Yes,
Then-
but yes, we
You
are
left him
admitting
out.
that his juniors were granted, but
Left him out.
during in service, the petitioner has never approached. Only after the retirement, the petitioner is claiming, my lord. And he is already out from the port, my lord. He has already missed the bus, my lord. Much.
If you have any judgments to rely upon, you please give me a list. Give us a list.
Give a
with,
list.
the para numbers so that we can at least quote.
Yes.
Heard Mr. Senti Yange, learned counsel for the appellant. Also heard Mr. E. Pidapong, appearing for respondent number
All the rest. 1 4.
1 to 4, as well as Mr. Joshua Sheki, appearing for respondent number 5. Hearing concluded, judgment reserved.
Much.
Chief Adjournment, you allowed to submit by list by
yes.
two.
Yes, make it
Yes.
as early as possible.
My lord. Also, please.
From the supplementary procedures for admission, item number 15.
And please, your lordship. Lordship, the instrument JDP is the judgment and order dated 23/7/2025, passed by the line single judge in WPC 136 of 2024. Order page proposed lordship. Lordship, the writ petition was dismissed on the ground that the petitioner has no locus to challenge the appointment of private respondent or father. But the challenges made in the writ petition was made on three counts, lordship. First, the advertisement dated 26/2/2024 was not in consonance with the Honorable Apex Court judgment. As verdict in the state of Odisha versus the state of Odisha and another versus Mamanda Mohanty, reported in 2011. 3 SSC 346, Lordship.
We are
Second,
issuing notice.
Lordship.
Admission, please.
Heard Mr.
James.
James Newman, learned counsel for the appellant. Also heard Miss Ina Holly,
Representing 1 to 4.
appearing for respondent number 1 to 4. This appeal has been preferred by the appellant Ningshu Kiu Yim Chungar, impugning the judgment and order dated 23/7/2025, passed by learned single judge in writ petition number 136/2024. Appeal is admitted. Issue notice. Petition records. Issue notice to the respondents. Since Miss Ina Holly, learned government counsel, has appeared for respondent number 1 to 4, no formal notice need to be issued to these said respondents. As regards respondent number 5 is concerned, the petitioner shall take steps for issuance of notice upon the respondent number 5 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
What should I?
For orders, item number 5.
Affidavits from what were the order petition of the day, so it can't receive petition. Item number? Yes.
May I please, my lord, lordship, here my colleague, Ms. Merve is handling the case.
Who is handling?
Merve, Ms.
Okay,
Merve.
okay.
She's indisposed. So if the matter may be taken up next week.
My lord, the IAs with regard to.
Condonation.
Day of 484.
So we have to hear them also. Heard Mr. Toshi O. Longkumar, learned counsel for the petitioner. Also heard Mr. K.V. Angami, appearing on behalf of Ms. S. Mere, learned public prosecutor, who submits that as Ms. Mere is indisposed, some accommodation may be granted to the respondents. Considering the submissions made by learned counsel, learned public prosecutor, let this matter be listed in the next week on a date to be fixed by registry.
So, Lordship, I'm appearing for respondent number 2, the victim in that present.
Okay. What is your name?
Lordship, Miss K. Kiki. Kejo Sano Kiki.
Also heard Miss K. Kiki appearing, learned legal aid counsel appearing for respondent number 2.
Lordship.
Show her. Yes.
For orders, item number,
You have filed any written objection? In this case, have they filed it? You intend to file?
Yes, sure, I'm sorry to submit like this, but I don't have any instruction from my friend.
Let us. Okay.
My lord, if it may be listed after 2 weeks, because I have a matter in the visible seat on.
Okay. Instead of 1 week, make it after 2 weeks on a date to be fixed by registry. In the meanwhile, the respondents may file written objection to the prayer for condonation of delay filed by the petitioner, if so desired by them.
I oblige.
for orders, item number 7.
Correct.
Your Honor, my name is Mudassir, as the public prosecutor.
This is item number.
7.
What is this?
Your Honor, this criminal appeal has been filed under section 21(4) of an IA Act challenging the impugned order dated 23rd/5/2025 passed by the London Special Judge Dimapur.
Granting bail.
Yes, sir. Your Honor, kindly issue notice to the respondents.
Delays there.
Yes, Your Honor, delays there. Continuation of delay application has to annex with that, sir.
Okay, heard in IA. Heard Mr. Mudassir Asad, learned counsel for the applicant. This application, this interlocutory application has been filed under section 5 of the Limitation Act, read with section 21 within bracket 5 of the National Investigating Agency Act 2008, praying for condoning the delay of 56 days in filing the connected criminal appeal, whereby the applicant has impugned the order dated 23/5/2025 passed by London Special Judge Nia Dimapur in connection with RC-15/2019/NIA/GUW. Stop. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by registered post as well as by usual mode within 3 days from the date of this order, returnable after 2 weeks. List accordingly.
Yes, sir.
You need 3 weeks. Okay, instead of 2 weeks, make it 3 weeks.
Your Honor, my humble submission, Your Honor, in this petition, there was some typing error regarding the order date, sir. Somewhere on the petition part, Your Honor, it has been mentioned order date 28th of May
Rectify it.
in the main criminal petition. Criminal
Criminal
appeal
appeal.
to. Yes, Your Honor.
Criminal appeal is
Two.
not yet admitted. It is subject to
This subject to admission.
subject to the outcome of this delay condonation petition. You may make a prayer for yes.
Your Honor, for any correction, we have to make separate application.
Yes, but that is subject to the outcome of this delay condonation petition. Suppose this delay is not condoned, then there would be no occasion to correct. So wait for this, let this delay condonation application be considered, then you may make prayer.
Okay. Okay, Your Honor.
For orders, item number 8.
Same, similar.
Yes, Your Honor, similar, kindly issue notice to the respondents.
Heard Mr. Mudassir Asad. The case is same case or a different case?
Different case, sir.
Okay. Learned counsel for the applicant. This application under section 5 of the Limitation Act read with section 21 within bracket 5 of the National Investigating Agency Act 2008 has been filed by the applicant for condoning the delay of 56 days in preferring the connected appeal, in which the petitioner has impugned the order dated 23/5/2025 passed by Learned Special Judge Nia Dimapur in RC case RC number 707/2019/NIA/GUW. Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents within 3 days from the date of this order, returnable after 3 weeks. List accordingly.
Lordship, I beg my lord's indulgence. Lordship, I may be allowed to make a mention for hearing item 10. This is a consensus prayer.
Yes.
If we can manage come up after 3 weeks, my lord.
These people are behind bars.
Yes, my lord. I was intending to make an attempt for disposal of the IA.
In item number?
Item 10.
No, okay, we are allowing. And Mr. Sentiange, Learned Counsel for the Appellant. Also heard Mr. KV Angami, Learned Public Prosecutor, as well as Mr. Foseco Pote, Learned amicus or engaged counsel? Learned amicus, Learned legal aid counsel, legal aid counsel, appearing for respondent number 2. Learned counsel for the appellant has prayed for an adjournment of 2 weeks due to some personal difficulties, to which the counsel for the respondents have no objection. Hence, the prayer is allowed. Let this matter be listed after 2 weeks.
Much obliged.
For hearing, item number 9.
Is I been late? Is late?
Yes.
What was the query posed?
Very post was, with regard to the additional affidavit, some of the employees who were junior to the read petitioner were appointed, service were regularized. So in this regard, I was directed to make query as regard how this things happened. Then the response received from the department is that
in the OM 2004. There's a provision where the criteria for regularization is seniority come merit. Here, the letter says that the regularization of those employees who were junior, the lead petitioner were appointed on the basis of merit. That's why the recommendation based on the performance report submitted by the concerned executive engineer.
Your Worship, under the scheme, Worship, the provision is seniority come merit. But that very provision has been justified in the OIM itself, in the scheme itself. The scheme is page number 55 in the memo. The memo will be page number 55. We can come to page number 56, that the relevant portion, clause 4.
Just. Yes.
Merit clause 4. Work charge employees who have the right to be considered first for regularization against 50% of all future vacancies of similar nature in the department, for which he possesses the requisite qualification. Such regularization would be considered on the basis of seniority cum merit. The next sentence is very important. This means that the senior most work charge employee in the relevant cadre will be regularized subject to his or her fitness for the vacancies. Seniority cum merit position has been clarified in this paragraph. The next paragraph. And we kindly come to page number 39 in the memo. My fitness for the post. Worship, initially I was appointed for a period of 6 months. The type copy is at page number 40.
Yes.
In the interest of public service, in most sincerity in of all official duties, Srimati Swinsu, work charge sweeper, has been given continuous service with Swinsu. So considering my sincerity in all the official duties, I was given the continuous service. So in order to assist the meritness in the performance of the duty of role, this is the test.
Seniority cum merit. Seniority cum merit unless the senior person is unfit. You cannot be considered. And merit if they are of equal merit, suppose if a person being is of higher merit, then he can.
As per this letter, as per the letter which my finance produced, you see that the declaration of work charge employee is based on your performance. As per the order which is just relied upon, as per the order issued by my controlling officer. Considering my sincerity in official duties. In the year 1980, also, I was given the skill of continuous service. And also, if the work charge employee has to be recognized on the basis of their performance, and this the APAR of an employee has to be assessed. APAR of 5 years. Work charge employees cannot maintain an APAR. And that's we consider by the Act provides so. Here's an Act. Recruitment board is there. The APAR has to be considered by recruitment board. Here's no such thing.
No, otherwise also your earlier submission that the criteria is seniority cum merit.
Seniority cum merit.
So unless the petitioner is found unfit for the post, He,
I cannot be wrong. Seniority come merit that finishing, he himself has defined in the policy.
Here it is more of seniority come fitness.
In active policy.
That is what they try to say, that if you're fit, you have to be given.
apart from this submission that learned single judge ignored this issue aspect,
Single judge was of the opinion that under the 2004 scheme, I should have been considered. Since in the year 2004, I was serving for more than 16 years.
yes.
That was an observation made by the single judge. In that observation came to be true.
Oh, yes, yes, okay.
This issue also before the learned single judge. This, the seniority, the issue of seniority was not.
It's a continuation of the repetition, is it?
The issue which I brought in the additional affidavit. This data was circulated in the department only after the disposal of the affidavit.
This is the last item.
Yes.
This data was circulated on 9 August 2023. In the appeal was disposed of on 26/4/2022. After the disposal of the appeal only, it came to the knowledge of the appellant, our respondent, this week.
Which one you are referring to?
In my additional affidavit, in Action 1. In my additional affidavit.
Page?
Page 7, in Action 1. This letter was circulated on 9 August 2022. And my writ petition was disposed of on 26/4/2022. This matter was heard by our Chief Justice on the last revision. And when I placed before the lordship this letter, it has allowed me to find additional evidence. By order dated 5/12/2024.
You have anything else to submit?
No, as per the scheme,
You have anything to say?
Anything to add?
Lordship, even if the petition is to be allowed on the basis of the additional affidavit, my humble prayer before my lordship is to kindly take care of the order passed by the learned single judge, because there's a contempt petition pending for non-compliance of the order. So there's just in continuation of that, learned single judge will have difficulties.
Once they comply with the direction passed by a lordship, Pandem will definitely close.
And when you have a contempt petition pending,
Yes.
move in the disposed case in the writ petition that we need extension of time because the writ appeal is pending. Why don't you inform that in the contempt?
Lordship.
You can inform in the contempt that there is a writ appeal pending.
Yes.
The writ appeal took time to decide, and therefore you need an extension of time.
Oh, yeah, as far as for now, it is pending, just pending, not
Pandem project is suspended.
suspended. Yes,
That's it.
but in the event, if my lord says, the impression I'm saying is, if
You had 3 months from the date of the order of the learned single judge to comply. The learned single judge gave you 3 months.
Yes, yes.
So you say that the 3 months having expired during pendency of the appeal, you may be in trouble.
Yes, it's already in trouble. So if now more or less any course of action has arisen, so my humble prayer is to kind of take care of that. If at all the petitions to be allowed on the basis of the additional affidavit. Otherwise, as far as the writ petition against the writ petition is concerned, as my lord also had observed the other day, I think we had a good case. But coming to the additional affidavit,
Heard Mr. K.V. Angami, learned government counsel appearing for the appellant. Also heard Mr.
Lima Wapang.
Lima Wapang, learned counsel for the respondent. Hearing concluded, judgment reserved.